Happy Sunday. Let's talk about a little bit more about the gerrymandered maps in Texas and what the lower courts did and what the Supreme Court did this week. For background, when Texas first started considering re-gerrymandering their congressional district maps, the senior attorney in charge of the Department of Justice Civil Rights Unit, a woman named Hermit Dylan, wrote them a letter basically saying that the currently existing congressional districts, several of them in Texas, actually constituted reverse racism against white people. Part of the whole point of the Voting Rights Act and things like pre-clearance and the Section 2 that the Supreme Court is considering right now to prevent racially based discrimination in voting and gerrymandering and things like that, was to protect the rights of Black and brown people and make sure that their votes actually had some meaning to them. And so when Texas drew its last round of maps, they had these things called minority coalition districts that boosted minority populations in certain districts so that the voices of those voters would actually count. Hermit Dylan, head of the Department of Justice Civil Rights Division, wrote Texas a letter and said, having these minority coalition districts is racist. And so Texas was like, that's the pretense. That's the pretense that we need in order to draw these new maps that Donald Trump wants us to draw so that Republicans will gain 5 more seats in the House of Representatives in Texas. So Texas draws their maps based in large part on this letter from Hermit Dylan at the Civil Rights Division. And they were sued over those maps. There was a lower court that had hearings and took evidence and did put out an extensive decision in that case with very specific findings of fact. The findings of fact said this is a racially based gerrymander that the Texas state legislature is doing in 2025, and that is illegal. It is unlawful. It is unconstitutional. It violates the 13th, 14th Amendments of the Constitution. It violates the Voting Rights Act. The lower court judge found, as a matter of fact, those things to be true. And so it went up to the Supreme Court, and the Supreme Court this week said no, this does not constitute racially based gerrymandering, and it is permissible. Now, why is that so mind-blowing to most of the attorneys that you know in your life? Because the Supreme Court completely ignored the lower court's findings of fact, which the Supreme Court is not allowed to do. They are not allowed to ignore them. They are not allowed to change them. They are not allowed to disregard them, or unless there is, it's called the clear error standard, meaning that the lower court, in making its factual determinations, made such a clear and unambiguous error in finding facts that relate directly to the outcome that lower court determined for a particular case. The Supreme Court's just simply not permitted to do that. But they just did it anyway. They just said, fuck it, who cares? And said that Texas gets to use their map. And which I think is a very negative step or predictor as it relates to the current Voting Rights Act, that is the case that is pending before the court, which deals with Section 2. And Section 2 says racial discrimination in voting practices and in gerrymandering are illegal and unconstitutional. it would certainly appear from what the court did this week that they're going to throw that out. And they're going to get rid of that final section of the Voting Rights Act that actually still has some impact. If they do that in the Confederate states throughout the South, you will see redistricting and gerrymandering, which will completely negate the voices and votes of almost every single black and brown person in the South. And will open up 18 to 20 congressional House districts and make it easier for Republicans to flip them from Democrat to Republican, potentially giving them the majority in the House for the next 30 years. And so a few years ago, there was a case called Rucho that did away with partisan. That basically said that if gerrymandering is based on partisanship, the Supreme Court's not going to review that. Before that, we had the Shelby case, which did away with Article 3, or with Section 3. It was either Section 3 or Section 5 of the Voting Rights Act that required states with histories of discrimination to go through a pre-clearance process anytime they were going to change their voting laws. And now we have this case that's currently pending before the court to do away with Section 2 of the Voting Rights Act, to basically legalize racial discrimination relative to voting and gerrymandering and things like that. And, it's like, I was listening to the Strict Scrutiny podcast yesterday when I was driving up to the mountains, and it's a great fucking podcast. Everyone should be listening to that. It's part of Crooked Media and the guys who do Pod Save America and Pod Save the World. But the Strict Scrutiny podcast is a bunch of women every week talking about the Supreme Court stuff, and they're fantastic, and they employ a very liberal use of profanity and vulgarity, which I enjoy very much. But one thing that has become more and more curious to me, more and more curious, or curiouser and curiouser, I don't know which one of those is proper. I just find myself wondering a lot about Supreme Court deliberations. Because everybody thinks that John Roberts is this institutionalist who cares deeply about the court as an institution. I don't know how he got that reputation, to be honest with you. But my God, I mean, John Roberts hates the fucking Voting Rights Act almost as much as Neil Gorsuch hates the EPA. But what are deliberations like in the Supreme Court now? Because the justices very famously, get together and they meet and they discuss these cases and they do certain things and they have debates among one. It's like, what must those deliberations be like now? With the three liberal justices, Alina Kagan, Sotomayor, and Ketanji Brown Jackson, just looking at the six conservatives and like, you guys are breaking the law. You're breaking the law. What you're proposing to do is explicitly illegal and unconstitutional. You're breaking the law. And like Brett Kavanaugh just sitting there going, whatever. It's like the current conservative majority on this court has destroyed the Supreme Court. They have destroyed the court's credibility. They have destroyed the court's believability. People don't take the Supreme Court seriously anymore. And, that has all happened on John Roberts' watch, the institutionalist. It's just amazing. It's like, the Constitution doesn't matter to the Supreme Court, the conservative majority. Precedent doesn't matter to the conservative majority. Statutes, case law, precedent don't matter to this current conservative majority. They've flouted all of those things and just been like, fuck you, what are you going to do about it? Because they know there's nothing we can do about it. It's disheartening.